What would an experienced use of force expert have to say about the Kayla Giles case? Stick around. Today you're going to find out. This is attorney Andy Marcantel and attorney Marc J. Victor. We are the Attorneys for Freedom, and today we have a very special guest in the studio that I'm very excited to talk to. But first, I got to check in on my buddy Marc. How you doing today, man?
I am fantastic, man. Today, I'm super excited about this video for a couple of reasons. Number one, we got a good friend, Jeff Hynes, in studio.
I was going to say, yes, he's an expert, but I consider we've worked so many times over the years with him on so many cases, many high profile.
It's been about a decade now.
Yeah, that I consider him more of a friend than just an employee of the firm or an expert, of course.
And just as important is that I'm drinking the best damn coffee I think I've ever had in my whole life.
Should we
today.
say something about the coffee?
Yes,
man. This coffee's really good. What's it called?
I can't believe how good this coffee is. It's called Blackout Coffee. I never heard of it before. I got some cold brew here that we make at our firm. People have been to our firm. They know we're pretty crazy about coffee.
We have an excellent coffee setup.
Yeah, so we got cold brew, Blackout Coffee. This coffee comes from our buddy Jared over at
Guns and Gadgets.
Over at Guns and Gadgets. I really like Jared. I follow him. He does great analysis. I love what he has to say. He's a friend. And he sent us some of this coffee.
No, we are not being paid for this
Not
endorsement.
a dime, no.
We haven't received this coffee for free. Wouldn't mind receiving some for
In fact,
free.
Jared doesn't even know we're doing this.
Yeah, this is
He has
the cold
no
brew.
idea, yeah. But it's the best damn
But
coffee.
do you remember this yesterday? You
Yeah.
were like, Andy, we should talk on the show about how good the coffee is because Devin, our front desk manager, who used to be a barista,
That's
by
right.
the way, that's one of the reasons why we have such an excellent coffee operation. But you told me, Andy, this coffee's so damn good, I want to mention it on the show tomorrow. We should talk about it. I was like, whoa, I haven't tried the coffee
That's right.
yet, Marc.
You were very skeptical.
I'm not going to shill for
Right.
some company that I don't personally endorse. You can talk about the coffee. You were like, Andy, you got to try this coffee right now.
I was excited about it because I knew you were going to change your mind after you had some of that coffee.
So Sarah brought me some coffee, and I tried the coffee.
You smelled it. You could tell from the first
I'm a
smell.
connoisseur, man.
Right, you could tell from the first smell, this is seriously good coffee.
This is excellent cold brew coffee, Blackout Coffee. Thanks, Jared, for sending it over.
There's something wrong with you two. You know that, right?
We're just really caffeinated right now.
I've had paralegals over the years who have said, you know what, Marc? You come in caffeinated enough. The last thing you need is more caffeine at the law firm. But, hey, it is what it is.
Let's get to the reason why we're here. It is our pleasure to introduce you guys to Jeff Hynes. And Jeff is a use of force expert with a very impressive background. Jeff, welcome to the show, my friend.
Thank you, Andy.
All right, so why don't you start by introducing yourself to our listeners?
Well, Jeff Hynes, retired Phoenix PD commander. I did 32 years with Phoenix PD. Went back to school about 20th year in my career, got my doctorate in education, went into education after my career, which ended in 2011. I've been in education for the last 13 years. But then post-retirement, I started doing case consulting and expert witness testimony. Same thing I was doing in law enforcement, but I wasn't getting paid for it.
You should mention a little about what you did at Phoenix PD.
Oh,
you weren't
my
just
gosh.
your typical street cop here either.
No, 32 blessed years, fantastic career. You think of it in the police department, I probably worked at the academy 4 times in training, so training is a big part of my background.
Yep.
The proficiency skills lieutenant over the entire training for the Phoenix Police Department. Our campus we had was 84 different user agencies. We had about 5,000 law enforcement officers come through our academy every year. So it was like a community college campus teaching everything from use of force, firearms, driving, defensive tactics. My specialty was use of force, hands-on, and shooting reviews. So for the department, when we did use of force reviews, they brought one of us from the training academy, the experts, to sit on these boards for use of force reviews on police shootings and use of force reviews on if we hurt somebody, if we used a technique that was seen as excessive, if it was something that got media attention, we came in and offered an opinion, an expert opinion on was this behavior valid or was it excessive? And so that started early in my career, and so it just seemed like a natural progression to go into that post-retirement. So for the last decade, I think I'm approaching about 100 cases now, and I do both sides. I do plaintiff and defendant. I represent officers. I also do cases that I find are egregious cases against law enforcement.
That's right.
Unfortunately,
we've used you on some of
Yes.
these cases in the past.
On both sides, too.
absolutely, on both sides.
What I mean by that for the viewers is just that we've had criminal defendants who were charged,
Yes.
And they were police officers
Yes.
that we defended because we believe they were active,
That's right.
good uses of self-defense. And then we've also used you to help us sue bad cops in civil rights cases and analyze
Absolutely.
those types of cases.
And so the key is just being objective. And part of my background was overseeing the Professional Standards Bureau.
Yeah.
Professional Standards Bureau in the police department for laypersons like internal affairs.
Right.
Professional standards is a nice way of saying internal affairs. We looked at all misconduct investigations. When you have an agency of 3,000 officers, you're going to have things that are going to come up. We had always had, when I was there, 150 open cases. Open cases that range anything from internally cases of violating policy to criminal cases of domestic violence. Unfortunately, we even did criminal cases against officers who had committed crimes. Not many of those, but we did those. But my specialty that I brought to the table was the use of force review. That was my area of expertise. So coming into this post-retirement was just a natural transition, and specifically the area of Second Amendment rights and Second Amendment rights and cases that people being charged and cases that you just look at that information and you just your head turns and goes, they charged what?
Right.
They charged that person for what? Right. And so that excitement, or I'll even use an academic profanity almost, but pissed off, it just makes you mad.
Right.
And you see somebody's rights being violated and being charged in a number of cases around Arizona, a couple in Flagstaff, one in Prescott Valley. But I want to be involved in those. And to the point, I said, I'll do those things pro bono. I think we had an officer in Flagstaff that we were representing. As soon as I read the case, I said, my gosh.
You were fired up. I remember that.
Bring me on board, and I don't care if you pay me for this one or not. I'm on this one.
That was a great one because that officer was very unpopular in the press. The press treated him very poorly, and he was charged with a crime, and we fought really hard for him and got a great result on that case. It was a high-profile case as well. And your contribution to that case was really instrumental. It's been great working with you over the years on so many cases. And you've now testified in many different courts and qualified as an expert witness. Why don't you talk about that just a little bit?
Both federally and state-wise. I go in now as a use of force expert on both excessive force or use of force and police shootings, and been qualified in both those areas. Love doing depositions, love being part of the process. I get excited. I get an emotional connection to the cases that I work. And once you get that emotional connection to a case that you're working, you dig deep. Right. You find the minutia and page 87 of a 1,000-page document that you say, whoa, wait a minute. The victim's daughter said this, similar to something like in this case here, where we're talking about, you say, they said this at the time of the interview, but then later on at trial they say something different. And so you bring that back up, and this was taken when it was the emotional part of the case versus the static part, which is years later when they go to trial. And that's the similarities of this case that we're about to talk about is right there. Those experiences in federal court, I love jury trials. I love depositions, everything that's part of this. As you can tell, I'm not shy.
Yeah, and I think it'd be fair to say, and I already know this because we've been working together a long time, you feel the same way we feel about the Second Amendment, which is to say if you are a competent, responsible adult, you should be able to have whatever you want. I mean, this is America, and it's supposed to be a free country. And look, if somebody violates the law and prosecutors want to charge them, fine.
Yep.
But just because you don't like guns isn't a reason to charge somebody with a crime because they exercised their right to self-defense, which doesn't, by the way, depend on the Second Amendment. It existed long before the Constitution.
Yes.
People who understand the structure of our Constitution. It doesn't grant rights. It enumerates rights. It writes down and identifies the rights that existed before the Constitution. You got a right to defend yourself. If you don't have that, you don't have a civilized society. Sorry.
And then just to put a bow on your very impressive CV, in addition to all of that great stuff and your history in law enforcement and your history as an expert, you're also a professor on top of all of that.
That's right.
Yeah, when I went back to school, I got my doctorate back in 2007 in education. And the question I always get asked, well, what does a cop need a doctorate for? When I was down at the training academy, the story is on one side of the table are all these, I call them baby docs. They go to school, they get their master's degree, they get their PhDs, And then they try to tell law enforcement or use of force experts their belief as absolute fact. Yeah. And you go, well, wait a minute. What type of practitioner experience do you have? And I have 32 years in the game, 32 years. And that's working every aspect of law enforcement and specifically focusing in on training in the academy and all these issues of hands-on defensive tactics, the less lethal items, the tasers, the beanbags, everything, de-escalation training, all those things. And so it made me mad. And I said, well, I'll tell you what, I'm going to keep my practitioner side, but I'm going to go get one of those degrees that you have so that you aren't looking down on this practitioner, right, and so that I can argue academically point to point that you raise. And so that was kind of the incentive of going back to school and getting that. But yeah, for the last 13 years, I've been a professor at Glendale Community College. I've also taught for ASU, Adjunct, NAU, Grand Canyon, University of Phoenix, Ottawa. You name the institution in this state, I've probably taught at it.
And you're teaching criminal justice, justice studies, things related to exactly what it is that you work on and what you do for us as a use of force expert.
Yeah, because it puts that side of my expertise to come in and to pick up a case like for your law firm is I'm teaching it. I'm living it. I'm practicing it. And when you go before undergrad students or grad students and they challenge your positions similar to what would happen in a court case or in a deposition, and I love that experience. So people say, well, your experience in law enforcement was 10 years ago. No, it's continued nonstop since my retirement 10 years ago. And I've always been in front of a classroom for the last 10 years. Mm-hmm. So currently I adjunct teach for Grand Canyon University and for NAU right now. And I love it. I love it. It keeps my skills sharp. It keeps the case study material current. And it gives me an opportunity to practice those skills, similar to the way that you present to a jury. You present to a jury just like you're presenting to a classroom. You look those juries in the eyes and you tell them with passion why you are here defending this case and why you're here talking about this and why this makes you mad. I don't use the pissed off phrase in front of a jury, but why it makes you mad, and they see that passion in you, they see that excitement in you for this case, and the plaintiff or the defendant sitting on the other side, they're going, wow, go, because you're saying my position in a much more articulate way. When you talk about, do injuries occur? Yes. But at what point does it cross that line that it's excessive? Or what point does it become egregious? What point does it become? That's not what the facts show. In a lot of cases I take on, especially when there's body-worn camera now, I wish if there's ever a video possibility in a case that you're involved in, review that before you do your interview. Be careful as what you're going to say because you're sucked into the spontaneous moment of that incident. Look at that video and say, oh my gosh, I didn't realize that I fired my full magazine. I swear I fired 3 rounds, but your slides lock back. And so you look at the video, oh my gosh, I did fire 17.
It's a good reminder that we don't always recall perfully exactly what happened.
No, almost never. Yeah.
And so those type of advices, when we talk to clients or talk to people who have asked for our expertise, is coming back. We may see something that doesn't match that initial statement, but then you go back and say, look at the video, look at the tape. This is what you said. Let's go back. And it's not saying, well, I lied. No, that excitement that pulls you in, the same thing happens in law enforcement. I can't tell you how many police shootings I've been out on where the officer will swear he fired 3 times and his slides lock back. And so the example I just used is truly that's real life things that happen. Mm-hmm. And so you've got to get through those minor points, those micro points, and focus on the big picture. And then you come back to what does the objective fact say? And you follow that. Is that the case we're about to talk about today? When you go look back at what convicted this lady that we're about to talk about, is that you go back into the minutia of the key interviews that happened at the scene or right after the scene, and you look at that information. There's your objective fact. What is said at trial is if it differs from that, guess what? I raise my hand and I say to the attorney, hey, let's go talk at the research. Do you realize you had this victim said 7 times, this witness said 7 times this story, but on the stand she's saying this.
All right, so let's set this up.
Well, before we dive into the case we're going to talk about today.
But there's so many similarities in how this case relates to other cases that you testify to and the research that you present the similarities are striking.
Well, I just wanted to say, and this is exactly kind of what reminded me of this, is one of the reasons why I think you're such a credible witness in the eyes of the state and why defense attorneys want to consult with you on these types of cases is because you always call balls and strikes, right?
Absolutely.
We brought cases to you where we think it's a good self-defense case, and you'll use your expertise and take a look at it and kind of take some of the wind out of our sails, and that's a good thing, right? Because we don't want to charge in head first on behalf of a client unless we're on very firm grounds, why we consult experts on these types of things.
And it's interesting because I get asked, well, Jeff, how can you be so definite in your analysis of this? So I've done thousands, and not hundreds, thousands. If you look at the criminal interviews and sitting through and overseeing a professional standards bureau where you have 150 open cases, there might be 10, 15, 20 witnesses involved in those cases. We had to review all those, listen to the tapes, verify the information that's being presented to us. And so you come back and just that validity of what you're hearing, that objectiveness. And so what I commonly do to an attorney that calls me is I say, I've reviewed the facts of your case, as I'll look at everything. And that initial review, it may take 4, 6 hours, but whatever it takes, that's okay. And I'll say, you have an 80-20 case here. And they'll say, well, how can you come up with something that sounds absolute? And I said, well, in my humble opinion, you're 80% to the good, but let me tell you about the 20% that I see are your Achilles heels, your faults.
Right.
And depending on how that's going to turn out in a jury trial, this is the area that is your weakness. And if this can be tightened up in any way, this is going to give you a very strong position to stand on.
I think that's a good segue into what we're doing today, right? Because I guess just to set this up properly, what happened was when we got the Kayla Giles case, right?
Sir.
We got pretty much the whole file. I thought, let's do what we would normally do. Yep. And so I called you up and I said, hey, Jeff, we got this situation here. Would you be willing to take a peek and give me your opinion on the case? And we sent the whole file over to you. You can, if you even want to talk about what you reviewed. But what I want to say, what we're doing here today is not trying to figure out whether Kayla was actually guilty here or was actually innocent here. I'm not even using not guilty, whether a crime was committed or not. That's not really the analysis. And as you say, it's a percentage, 80-20.
Yes.
We almost never have a case where we say, oh, slam dunk, definite guarantee this is going to be a good shoot or a bad shoot, because nobody knows.
I've never seen one of those.
Right. We never know what a randomly selected group of people from the local community is going to think is reasonable. So we're predicting what we think. So there's always risk. The question here on the Kayla Giles matter is, was this thing defensible as a self-defense case, right? Was it a slam dunk loser, no way this is self-defense, this is premeditated murder, or is it in a different category, which is, it's arguable. It could go either way. We know what happened, right? She got convicted, and we can talk about that. But I think a good place to start might be what she was charged with. Premeditated first-degree murder.
Yeah, it started out as first-degree premeditated murder. And I remember seeing a video, maybe we can show the clip of it, with Tim Schmidt, who is the president and CEO of USCCA, saying something to the extent of, the reason why we disclaimed liability is because at some point it became perfectly clear that she had committed premeditated murder. Not even the prosecutor in Kayla Giles' case agreed with Tim Schmidt from USCCA. In fact, it was originally charged as premeditated, but because of no likelihood of conviction, the prosecutor ended up dismissing that charge and then re-indicting on a lesser degree, on second-degree murder, which does not have premeditation as an element.
But that tells you right there that the prosecutor who reviewed the case, when faced with the reality of proving whether or not this was premeditated, said, I'm not even going to take a stab at that. I'm dismissing first-degree murder, and now I'm going to re-indict on second-degree murder, which in essence is going to be an intentional killing that is not justified.
And this makes perfect sense to me. I want to get your take on it, Jeff, but this is the narrative right now around this case, right? That she had researched how to kill your husband and get away with it. She had made statements, I can't wait to kill him. She had gotten USCCA's insurance because she was planning planning to kill him. She got the gun shortly before the incident. But the whole time swirling around in my head when I looked at the incident itself, the reason why this constant claim of premeditation in the narrative surrounding this case immediately bothered me was because it's clear he follows her to her vehicle and attempts to open the vehicle. I said, hold up, so did she plan? Is the narrative that she planned to get him to, is she a master psychologist and knew exactly what to say to him to get him to come over to the car and yank her door open so that she could fire him? It's just never made sense to me at all.
What is totally missing from this, and so, Mark, when you let me look at this case, I drilled down into the micro part of it. First of all, where's the mention that she was a domestic violence victim? Where is the battery syndrome? So this is somebody that is 5'3", 114 pounds. Her husband at the time is an MMA fighter who's like 6'1", 230.
He's 100 pounds heavier than her.
And is a skilled person. In law enforcement, that person would take us up to the next use of force level,
right?
Just even in response to him. So off the table. And so I'm looking and drilling down into this. I said, well, this is somebody that's in fear for her safety. This man has threatened her. Now, is there an argument back and forth that they threatened each other and there's this and that? But
I'm sure she was very threatening towards him.
Oh, yes. She's looking up at this big tree. And so she's going to take precautions as she can. Go get a gun. You fear for your life against this man who's already threatened you, who's already harmed you. And your response to that is within the law that you can do that. So she arms herself.
And when we spoke to Kayla, she had a very good explanation for the timing, right? The timing is a big talking point for people.
Yes.
Well, it was shortly before, it was like a couple of weeks before the incident that she went out and purchased USCCA
because she
insurance.
was in a heightened fear condition at that time.
And it actually coincided with when he started bringing guns to the child custody exchanges. So it has I'm satisfied by that explanation.
And I think it's important to note that this is one of the claims of error on appeal, is that the trial lawyer, remember what happened here, right? She purchased USCCA's policy.
Yes.
After this incident happens, she calls USCCA. Right. First, she calls for help immediately. She can get an ambulance down here. She calls for help. She calls USCCA. And USCCA says, no problem, we got you. They pay $50,000 for an attorney who they select to represent her. Andy and I spoke to that lawyer. That lawyer told us, Mark, I've been doing this a long time. You've been practicing longer than me, and I got 30-plus years representing people in the criminal justice system.
Yes.
He said, this is one of the better self-defense cases I've ever had. I don't know why they dropped this case, why they said, you know what, they won't let me fund the case. That's what happened. And in the records, and I've got a whole bunch of stuff here. We don't have the whole file here, but we have it at our firm. It's very clear that he turned over information to the insurance company as he's required to do, right?
Yep, under the USCCA contract.
But where was their use of force expert? Instantly, when I read this, I go, my gosh, you've got a justification case here that jumps off the freaking page. You have a 7-year-old daughter who multiple times, I think we counted it earlier, 7 times, she says to the forensic interviewers that her father actually leaped towards and
he was jumping
at her. He opens a door in an aggressive way. He jumps at her. He's using profanities at her as he's coming closer to her. So who wouldn't be threatened by this? This is a 5'3", 114-pound female that now is armed. And if this idiot's going to come and do harm to her, she's in a perfect position to defend herself, which she does. And so you go back to the micro facts of this case, you have an independent witness, well, the daughter.
Well, let's drill down on that for a second. So the daughter is 7 years old, right? And she is interviewed on the day of the incident.
Which would be perfect timing.
September 8th, 2018.
And interviewed by forensic interviewers, somebody who is skilled interviewing children in order to get the truth out
and
of them.
I have that transcript of that interview right here in my hands. And she says on several different occasions, on page 8 of the interview, question, what was happening? Answer, Thomas was in front of Mama. He was jumping at her. Then questioner, answer. And then Mama grabbed the gun and it says, Click. On page 9, she says, we were supposed to meet Thomas there, but then whenever Mama first got in the car, he opened the door and then jumped at her. She says on page 10, well, Mama shut the door and then Thomas opened it. She should have just locked it. Page 12. Question. Okay. So tell me about, if you can see, what was Mom doing whenever Thomas was falling to the ground? Answer. She was in the car calling the police and the ambulance and all that. Okay, next answer. I'm not sure what she was trying to get her arrested, but she was trying to find someone to help Thomas. Page 13. Question. I know that you said whenever y'all first got there, they were parked right next to each other with a couple of inches in between. And at first you said that Thomas went up to Mom and was like jumping on her. Answer. No. Jumping at her. Page 14. Question. Okay, so which car did this happen at when Thomas jumped at Mom? Did it happen at Mom's car or at Thomas's car? Answer. At Mama's. She answers again. No. What I saw was Thomas jumping at her, then Mom shot him. That's page 14 of the interview.
Those micro points are critical. When a use of force person looks at this report and looks at these interviews, I'm doing the same thing we did in your office. We're checking off how many times she says it and what key words is she using. It adds to the justification side of it. Mm-hmm. How they miss that, it baffles me.
Page 17. Question. Have you ever seen Mama get hit before? Answer. No. Well, no. Except for that time when Mom threw the pan, Thomas jumped at her, and then he slammed the door on her leg, and then she got him by punching and hitting and all that. That's the earlier incident they talked about. Page 19. Question. And how about Mom? Tell me how Mom was after it happened. Answer. Well, she was really not happy of the way he jumped at her and all of that. Page 20. Mom was like right there. He jumped at her, but she was trying to go in the car and all that. Then he, whenever he was shutting the door, he opened it, and then, question, and whose car was this happening at whenever Thomas was jumping at Mom? And he, answer, Mama's. Question, Mama's car? Okay, so after Thomas reopened, when you said Mom tried to close the door again, Thomas opened the door again? Answer, 27. And then she pulled her leg in. Thomas opened the door and then jumped at her. Shot. Page 28. All right, so Mama was trying to get back into her car. And you said that she was pulling her door back. And Thomas yanked it back open. What was the very next thing you remember right after Thomas yanked open the door? Answer. That's when I heard the gunshot. Okay, so we counted 7 times that the daughter, on the day of the incident, made it very clear that the victim, Thomas, the person who died, I don't know if we should call him the victim or not, Kayla goes in her car, closes the door. We heard Kayla said she didn't have enough time to lock the door, so she wasn't able to lock it. This guy gets out of his car, or wherever he is, walks over.
Pursues her,
opens the closed door.
To have another confrontation with her.
And then, according to the daughter, jumped at her.
That he's initiated.
Now, I think it's very important to note something here, what happened at the trial. I have the Court of Appeals decision right here, and how the Court of Appeals talks about this case is very differently. So I've got the Court of Appeals decision here, and the Court of Appeals is summarizing the evidence at trial, and I want to read from that case. Quote, it also heard the testimony of defendant's daughter that Thomas walked to the car and opened the door rather than lunging or jumping toward it, end quote. So the testimony at trial, 3.5 years after the incident,
of course,
after 7 times the daughter saying he jumped at her, he lunged at her, she at trial says there was no lunging or jumping.
Your use of force expert would have pointed out that initial interview saying, well, let's go back over the justification aspect of this case. And here's the code. Here's 13404, Arizona Revised Statutes. Let's look at how that looks and meets the elements of justification of use of force. In this case here, so she can say whatever she wants on the stand, but your use of force expert comes in, your policies procedures expert comes in and says, wait a minute. Let's talk about the 7 times she said this at the initial day interviews by a forensic interviewer. And so I'm not calling the young lady a liar, because 4 years or 3.5 years later, her memory's going to change. She's got older. She's going to have a different, what type of pressures is the family placed on her? What about the grilling back and forth between the prosecutor's office and tightening up that story? And I'm not saying that she's misled or she's lying. I'm saying the counterpoint and the reason why a use of force expert is so important is come back in and say, I'm called up and said, well, let's talk about the justification for the shooting. And I go back and I said, well, let's talk about this initial interview that took place at the scene by a forensic interviewer who said this. The question would come back, well, does that validate your position on this being a justified shooting? Well, of course it does, because you have somebody that's not the two parties that's involved who witnesses this and not just offers her side of the story once, but 7 times.
Well, let's talk about why this is so important.
Yes.
Because in the case, the Court of Appeals cites the Louisiana Revised Statute 1420A4A. A homicide is justifiable, and this is 4A, when committed by a person lawfully inside a dwelling, a place of business, or a motor vehicle as defined in a different section, when the conflict began against a person who was attempting to make an unlawful entry into the dwelling, place of business, or motor vehicle, or who has made an unlawful entry into the dwelling, place of business, or motor vehicle, and the person committing the homicide reasonably believes that the use of force is necessary to prevent the entry or to compel the intruder to leave the dwelling, place of business, or motor vehicle. And then it says subsection B creates a presumption that a person lawfully inside a dwelling, place of business, or motor vehicle held a reasonable belief that the use of deadly force was necessary to prevent unlawful entry thereto or to compel an unlawful intruder to leave the dwelling, place of business, or motor vehicle when the conflict began, if both of the following occur. 1, the person against whom deadly force was used was in the process of, this is the big takeaway here, unlawfully and forcibly entering or had unlawfully and forcibly entered the dwelling, place of business, or motor vehicle, and then the person who used deadly force knew or had reason to believe that the unlawful and forcible entry was occurring or had occurred. What this case was about was whether or not this was forcible.
Yes.
And with that Donner backing off that statement at trial 3.5 years later, that he jumped at her, the Court of Appeals found, well, this wasn't necessarily a forcible entry. He just opened the door.
Yep.
And they say that you can find this in the video, but if you see that video, and we should show that video.
It wasn't there.
So here's the video we're talking about. Now, Jeff, you've watched that video,
yes.
right?
And that video was taken from a Sonic drive-through across the parking lot.
It's not clear. It's not conclusively clear that there was this aggressive opening, but there also, and going by the statements of the witness, going by the statements of the alleged suspect here, who is expressing fear, she is heightened. And so here he comes in an aggressive way to her car. He's using profanities. He's obviously mad. He forces open the car. He lunges at the car or jumps at the car. And as the door opens, in fear, as we've gotten from her interviews, she fires. Incredibly, absolutely, clearly justifiable in firing that round. And so all the smoke and mirrors that comes up later of the side issues, you got to focus, and this is the objective side of somebody coming in and independently looking at this, is objectively these things happened.
How does she?
Yeah, hold up. I want to point out something really important you just said. Let's grant that she was at some point planning to kill her husband. Let's just go down this hypothetical. Let's say that 2 weeks before, when she purchased USCCA insurance and purchased the gun, it was her plot at that time to kill her husband. She was premeditating a murder. Okay. Things can change. Things can change. The state has to prove every element of their case beyond a reasonable doubt. So what we're analyzing and what the focus should be, rather than all the auxiliary issues, is in that moment, at the time that she pulled the trigger, was she justified under Louisiana law to discharge that round? That's the question. All the rest is, as you just accurately put it, smoke and mirrors.
Do you really think she planned a murder? But I know, I'll make the exchange at Walmart, and then I'll walk to my car and close the door and get him somehow to walk to my car, open the door, and lunge at me. That seems ridiculous. But let me just get this in here.
That's not the
why would you do
that's
it
not the facts of the case.
Why would you do it in front of your kids?
You wouldn't do that.
Let me tell you what the Court of Appeals said about that video, and people can judge this for themselves. Reading from the Court of Appeals decision, more importantly, the jury saw the surveillance video from the Sonic restaurant that showed Thomas approach the car and open the door. The video did not show Thomas lunge or jump at the car or open the car door violently. Defendant got into the car and closed the door. Thomas opened the door and within seconds fell backward to the ground. Do you get that from watching that video?
No. It's not an absolute, wow, he rushed at the car, he pulled the door open, he threatened her. But what you have to do is, when you look at that, okay, he did open the door, he did walk towards the car, he did say these things according to the person who shot him. The independent witness, the daughter, says 7 times that he jumped, lunged, or aggressively, you can interpret what he did as aggressively went towards that car. You cannot discount that. So when you watch a video, that's one piece of the objective information you're looking at. And if it's conclusive, fantastic.
Well,
if it's not, like in this case, it wasn't conclusive.
Here's one thing that is conclusive from the video.
He opened the door.
He pursued her.
Yes.
Yep.
And he opened the door.
There's no
He opened
question
the door
about that.
So I guess at that point, knowing that he's pursuing her and opens her door,
Yes.
is it more likely that he's peacefully opening the door,
the preponderance
or aggressively
the preponderance is on her
opening the
side.
door?
So let me ask you this question, Jeff. Even if you take the daughter's statements on the day of the incident, the 7 times, yes, I saw Thomas lunge in, and you go with what the Court of Appeals says, the video, I mean, I couldn't tell from that video whether he lunged in or not, but they think you can. So if you take the lunge out of the analysis, let's just say the actual facts that come in at trial are just simply that this was an ugly divorce situation. There was pre-existing domestic violence issues between the two.
Yes.
It was hostile. There were orders of protection flying.
She's in a heightened sense of security right now.
No question about that. She drops the kids. She goes to her car. She closes the door. And this 100-pound heavier MMA fighter then walks across. These are the undisputed facts. Walks across, grabs her closed door, and opens it. And don't assume a lunge. Don't we still have a defensible case of self-defense here?
Absolutely. And then you look for the other things that validate or mitigate or aggravate this. And what I'm looking for is statements. So her statement says, I was in fear. I was shocked. He's coming at me. He's bigger than me. He's harmed me in the past.
Well, let's talk about something really important that you just brought up. And Mark started going down this path earlier, but I think got derailed a little bit. But one of the reasons why there might be an argument for ineffective assistance of trial counsel here would be the fact that there was never a domestic violence expert to talk about battered spouse syndrome. You want to say a few things about that?
I can't even comprehend this. I oversaw that bureau for 3 years. I had the Family Advocacy Bureau. We investigated 60,000 calls of domestic violence every year. We took over 6,000 reports, about 5,500. Of those, 3,000. So just the numbers, the volume of. So I'm making this opinion, this statement, based on 3 years doing this. You cannot take that off the table. In the issue of domestic violence, the fear factor on the person who is the subject of this domestic violence, that has fear to their core, who goes out and says, I got to do something. So she goes and buys a gun. Good for her. She's feeling better about that. She has the weapon to defend herself. But she's in a heightened state. So here he comes, and now we can say, was it aggressive? Did he jump? Did he lunge? Did he pull the door openly? He walked. He got there. Information says he did those things. Then he opens the door. In fear she shoots him. It is an incredibly valid, justifiable case
Yeah,
of self-defense.
In order, if we had an expert who could talk
Yes.
about her past and her kind of the dynamic of the
Yes.
violence in this relationship and that fear
And also
that
the
you're
things that happened to
describing.
her in the military. She was also a victim of abuse there as well.
Yeah, as criminal defense attorneys, we might use such an expert to
Yes.
argue that, okay, what we're talking about, we're trying to assess whether her mental state at the time she pulled that trigger was reasonable. The argument might be, this is reasonable, even if you find it's not reasonable for a normal person in this situation, which very arguably, as we've been discussing, it is.
Yes.
But even if you reject that, is this reasonable for somebody who has this life experience, who has this
Who's
type
been
of
a victim
of domestic
Yes.
violence? And this
He
is
was,
what we get.
as I understand
experts for.
the facts here, she was knocked out by this guy on an earlier issue of domestic
This
violence.
man is
We-
an
we heard
MM.
the daughter
he
mention
is a fighter. He is a skilled fighter, and she's half his size. Of course, she's going to have fear that he's coming to hit her or beat her or do something to her. It doesn't matter what that something is, but she's in fear for her safety. And you can split hairs with me here. Was it I'm in fear for my life or I'm in fear from getting beaten?
Serious physical injury. yeah.
Exactly. So as soon as he opens that door, he's fair game. And if he opens the door, shuts it, and walks away, now that's different.
right.
We all agree on that.
Yep,
but in
we
this
agree.
case here, he is actively
He
pursuing
pursues.
into the car.
So to be clear here, I would argue, and so is her appellate lawyer arguing, that a competent criminal defense lawyer, remember, this is not the lawyer that USCCA paid. They revoked that lawyer. She had to come out of pocket and hire somebody. The person she hired failed to call a domestic violence expert to get on the stand and explain how these past incidents.
I can't even comprehend that lawyer did not do that. I can't even comprehend that.
Her appellate attorney has raised this on appeal. 2 issues on appeal for ineffective assistance of counsel. Number 1, trial counsel should have called a domestic violence expert to the stand to talk about her mens rea, what was going on in her head at the time that this incident happened. That wasn't done. That's ineffective assistance of counsel. Second issue, that trial attorney damn sure knew that this was a very high-profile case in a smaller town. People literally knew of her ex-husband, the deceased here, knew the person. It was
in the jury pool, people were like, yeah, we know that person. You know,
I think one of them was a friend.
Yeah.
Even.
And he says, look, I want a few extra strikes here because there's so much pretrial publicity. But he never moves to say, hey, we should change venue here and put it in a different place. So she raises those 2 issues on appeal. One of the first things I said to her when I talked to her is, you know, you can't really usually raise this stuff on appeal. And she says, I know, I threw it out there. And then there's a good reason for this because there's not enough information in the record. You raise this issue after the appeal is done. And this hasn't come up yet. So the question of whether Kayla Giles, trial attorney, was ineffective at trial has not been litigated yet.
Wow. The points that you've just raised, I can't comprehend somebody not doing what we're discussing here. Is there that much of a difference between Arizona law being practiced here and the experts that you have here than Louisiana? Probably, I'm assuming. But why you wouldn't call a domestic violence specialist to talk about the mental position that she's in? Now, could somebody that's your use of force or your police policies expert do that? Probably. I'm the exception. I oversaw that bureau for 3 years. So saying that, we would want that trained person to come in and make that absolute. These are the psychological journey steps that somebody goes through when they are the victim of a domestic violence. But somebody who's double your size and is a trained fighter.
Here's another thing that was disturbing to me about Kayla's story, specifically her experience with USCCA. As we mentioned earlier, Delta Defense, the insurance company that works for USCCA, disclaimed liability once the attorney sent some of the state's evidence over to them, and then they unilaterally, and even over the attorney's objection, decided this is not a self-defense case, we're disclaiming liability. But one thing that was really troubling from our conversation with Kayla was she said all of the evidence hadn't even been given to them yet at the time that they made that decision. And one critical piece that had not been given to them was the interview with the child.
Oh
that was
God.
Can you imagine this?
And so here I look at it basically over the course of an evening, and that jumps off the page at me, and I'm saying, well, you've got an independent person here that said this.
And the lawyer who they paid is after he's informed they're not going to cover, he's like, hold on a second. I got this interview with the daughter where she says 7 times he jumped at her. He lunged at her while she was in the car.
Exactly.
I still don't even want to hear it. We're not covering this case. Sorry.
It's like
it's unbelievable.
It's like everybody had made up their minds. This is not a defensible case. Everybody involved, from Delta Defense.
Well, how
to
could
USCCA
we
to
look
the
at it?
media.
How could I look at it and say, "Are you kidding me?" This one here. My advice to you guys: take this one. You have, even walking out the door, a 70-30 and 80-20. This one has a lot of ground to stand on. I would step on the stand on this one in a second.
The whole thing stinks. I feel like she got hosed.
And of course,
she got hosed.
I agree with you. She got hosed.
And of course, I got the decision here: Kayla Giles versus Delta Defense. And it's only a couple of pages.
So
because
she sues Delta Defense.
She sues Delta Defense. And you guys should have covered me. And essentially the court says, hey, the policy doesn't cover criminal acts. She was convicted. That's the end of that. Goodbye.
Wow.
Now think about that in the context of a self-defense case, right? Wow. What percentage of self-defense cases end in either a plea, right? Because you're usually dealing with a mandatory minimum prison sentence. And a lot of people are going to want to not roll the dice at trial.
Yep.
Because they just saw what happened to Kayla Giles and happens to a lot of people. I'll cut my losses. I'll take a probation. Okay, well, that happens. You're now guilty of the offense. And if they've got something in their contract that says, sorry, we don't cover criminal acts, you got no recourse. And that's exactly what happened to Kayla Giles. She was found guilty. And if you're found guilty or you plead guilty, at least under this contract that existed at the time, sorry, they are totally justified in dropping you.
Unbelievable.
So without reaching the question of whether or not she's innocent or guilty, because as Marc said at the beginning, that is not our purpose of this video. The question is, was it at least an arguable case of self-defense? And
much more than that.
I think it is more than that.
Much more than that.
Yeah, but just that baseline threshold of, is it a case of arguable self-defense? The narrative right now swirling around this
Absolutely.
case.
I mean, here I'm bringing 32 years of law enforcement experience. I'm bringing 10 post years of doing these type of cases and use of force reviews and shooting reviews. This is an incredibly defendable, justifiable case of use of force.
And we sent you the whole file.
Yes.
You've reviewed
everything.
the entire file on this case. And before our discussion, when we talked, and I said, hey, have you looked at the file? You were like, this is an easy one. Of course this is a defensible act. I mean, we could probably go further. I think this is a legitimate act of self-defense.
Yes.
Notwithstanding her statements, which she said was kind of stupid, right?
Yep.
When people say, I want to kill him, I can understand why she felt that way with this guy. But notwithstanding that statement, notwithstanding the fact that she's researching the law on self-defense, notwithstanding the fact that she purchased self-defense insurance, notwithstanding the fact that this wasn't a premeditated case.
Yeah, and that's why, that reason right there, that even the state said this is not premeditation. We can't prove premeditation to this jury. Honestly, to me, in my legal opinion, makes her statements previously about, I could just kill him or I want to kill him, less important. Throw him out.
Right.
I would have moved to exclude those statements, because we have to independently assess that at the time that she pulled the trigger, was she justified in self-defense? That's the question.
She was.
That's all that matters.
This is so clear within the realm of an arguable... I agree with the lawyer that USCCA paid $50,000. In fact, if this case came to our office, this would be one of the best self-defense cases we ever had at this
We
firm.
rarely get them this arguable.
Yeah.
Awesome. Fun discussion, guys. I always love talking about this case. You know what? This is funny because we've had this conversation many times on many cases before, right? Except we just happen to be surrounded by cameras right now. But this is this is basically just another day at the office.
This is what we do.
This is conversation about a case that
I wish we had this case.
I wish you did too.
Yeah.
I would have gladly taken this case.
This would have been a fun one to do.
Yes.
All right, everybody. Thank you for tuning in. If you want to learn more about our program, go to attorneysonretainer.us to learn about our self-defense program and what it can do for you. I want you to also go check out attorneysforfreedom.com to learn all about our law firm. And you can learn a little bit about Jeff while you're there, too. We love working with this guy. And learn about the philosophy of the law firm, how we argue for cases, how we defend our clients. I'm sure you're going to love everything you see there. If you like this video, be sure to like, comment, subscribe to the channel, and leave us a comment down below, and we'll respond to you. If you have anything you want to ask Jeff or you want to ask our attorneys about this case and our analysis, feel free to leave it down below. Until next time, this has been Attorney Andy Marcantel, Attorney Marc J. Victor, and Jeff Hynes signing out. Peace.